Thank you.
Ms. Zeldin?
May it please the Court, my name is Elizabeth Zeldin, and I represent AH, the appellant in this action. AH seeks that this Court adjudicate her to be a full parent to the child that she has parented since birth, and that she be charged fully with the obligations of parenthood. It is a role that both AH and MP envisioned for this child since the child's birth and that they planned for.
If your client wanted to be a full parent, why didn't she adopt the child, which she fully was in a position to do? I mean, you can't not adopt the child and then come here and ask us to fix it, can you?
Your Honor, it's a child-oriented inquiry. What we're looking for is to protect the child's relationship with AH.
But your client wants legal rights, not, I mean, this is beyond visitation. You're saying we want full parental rights, legal rights over the child.
That's correct.
And you could have gotten them by adopting the child, which was proposed. Your client declined to do so.
No, she didn't decline.
Well, she didn't execute the papers.
MP withdrew her consent before my client completed the adoption.
After how long was this pending?
Well, many people adopt their entire families at one time. There's no time. There was.
But you and
the
your
uncontested record was, Your Honor, that there was no agreement between the parties as to when the adoption would take place. And what the parties did do in order to protect this family, which is really what their goal was, is to institute numerous devices so that this child would be protected from incursions by third parties. What was never anticipated, and I have to concede it, is that the other person who had parented this child would withdraw consent after she had allowed the parent
all right.
to start.
How the child was conceived by agreement between the plaintiff and the defendant, right?
That's correct.
Right. And how long? And the agreement was that, in part, that both the non-birth mother would adopt the child.
At some point.
At some point. So how long passed while this was pending? A year and a half?
Maybe a different way of asking the question might be this. Assuming that one has expressed an intent to adopt a child, in other words, we are in the murky area where there are various indicia of parenting. To what extent was it permissible for the trial judge to take into account that the adoption had not been concluded, not as an indication that there was an agreement that it be done by a particular time, but that what the trial judge is looking at is two adults, and sometimes there are more, coming in and out of a child's life?
I think that's exactly.
Okay, and
excuse me.
Bear in mind that we are in a commonwealth where your client was fully able under the law to adopt the child. I'm not saying she should have done it the day after the child was born, but to what extent was the trial judge, could the trial judge take into account that when there was this total breakdown, that had not been accomplished?
I think that what the trial judge should have done, in the way the ALI would instruct, is that that's one indice as to whether or not there was an agreement that AH parent. And in this case, it was clear that for the entire 18 months, AH parented, and upon the conclusion of the relationship, MP came to court, asked the court that she be allowed to receive child support, filed answers repeatedly in this court that my client be allowed visitation, and that she get child support, something that is only ordered to a parent, received child support. So basically, certainly in terms of agreement, I don't think there's ever been, that's the way the ALI looks at it. And again, what we're really looking at is...
Can I interrupt you for a minute?
Excuse me.
While we're talking about the ALI, and maybe I've got this wrong, and you can correct it, but before, don't they suggest, the ALI, that before a court gets into this de facto or estoppel concept, that there has to be a 2-year relationship? And that's not met here, is it?
No, Your Honor. Actually, there are, if one looks at the tentative draft number 3 had the requirement that there be a substantial period of time compared to the age of the child. Tentative draft number 4
Well, let's just look
described.
at the final draft.
Yeah, what's the final draft say?
The final draft has basically five criteria, or six criteria: a legal parent, a de facto parent where there's a 2-year requirement, and then parent by estoppel. And then within parent by estoppel, subparts 1 and 3, one is if a person is obligated to pay child support, there's no 2-year rule. And then the criteria that my client falls under would be subpart 3. And that's really a unique category where they've planned for a child since birth.
She's been living with the child since birth. Also.
Living with the child since birth,
Well,
accepting full...
The triggering mechanism, as I recall, is whether or not two people plan for a child, have the child, and then live for a period of time is a little different than where the child exists and an adult comes into the child's life and then parenting relationships are established. Correct?
I think that really is one of the
That raises a question that
distinctions.
troubles me. Your position may well have a great deal of validity, but if we were to adopt your position, what prevents several people coming in before the child is an adult, and each one claiming to be a de facto parent? The next one would, of course, not be there from the time of conception, but the next one could develop a relationship with MP on the basis that the next person is very anxious to be in a relationship where there is a child and very anxious to be a parent to a child, gets into a relationship with MP, has extremely close relations with the child for 3-4 years, does everything that is required to be a parent legally and in our society in every way, and then that person wants to be a de facto parent, and then that's repeated. What's going to happen?
This is exactly why you want AH to be the parent, because if AH is the parent, then, and you use MP's next romantic partner, in order for her to be the de facto parent, she would have had to perform a share of the caretaking functions, at least as great as that of the other parent, with the consent of the legal parent. So she'd need the
In other
consent
words,
of...
there's no suggestion under the ALI that you can have more than 2 parents, correct?
Actually, Your Honor, in the comments, there is the suggestion that there could be...
Only if you've got the agreement of the then legal parent.
Exactly.
Correct?
Which
In other
we
words,
clearly don't have here.
You have it at the relevant time periods, Your Honor.
It seems to me the relevant time period is when this litigation started.
And at that time, MP went into court and asked the court to establish an access schedule, asked this court to give her child support, which is only permissible. You can only ask for a child to get child support if someone is a parent, had participated in co-parenting counseling.
Can I ask you two things about the ALI? One is, I notice that when it comes to parenthood by estoppel, i.e. the concept that you're going to make someone a full-blown parent with all of the rights and obligations, that is, to be reserved for situations when adoption was impossible or impractical.
I don't believe the comments say that.
Well, that certainly is what's represented in the other side's brief.
As a matter of fact, the comments don't say that. The comments specifically say, and I believe that this court
I think
has...
the comments say that you take adoption, the availability of the adoption. In other words,
it can be considered a factor.
Can be considered. That's why I asked you to. So
Right,
here
I'm talking about for parenthood by estoppel, not de facto.
No, parenthood by
the same
estoppel.
comment.
Parenthood by estoppel. Then the other question is, can you cite me any case where someone has been given not just visitation rights because of de facto parenthood or harm to the child, but full-blown status of parent over the objection of a lawful, fit parent?
Oh, there are many cases, Your Honor. Are you asking specifically on the
Not
theory?
de facto parent, parenthood by estoppel with the full panoply of rights.
Well, Your Honor, I think the best one is the recent Washington case, In Re LB. And in that case, there is an adjudication of full parental rights. There's a discussion of parent by estoppel and de facto parenthood. And I would suggest, Your Honor, that there are a number of cases that are using different terms, even in re paternity of Cheryl, for example, where really the estoppel principles are what are being used once there is an established parent-child relationship. And again, I'm not saying that one can come in and without several important thresholds being met, be a parent. I think that it's important that there be consent. I think it's important that they live together. I think it's important that the parent has assumed the obligations of parenthood without the thought that they will
Well,
be.
these are things that you think is important, but it seems to me
And
when
this is what the commentators have thought is important.
when the legislature drew up its version of what it would take for someone who is not a lawful biological parent to become a parent, it set up this procedure called adoption. And it has various requirements, not just the consent of the lawful parent. I'm not aware of any time when there may have been an agreement and that at some later time when the fit parent objects that an adoption is still forced down their throat. I've never heard of such a thing. So consent, there's usually some investigation, it's not something you can just go do. They've set their requirements. And they, as we've explained, in this state, happily, this was available to your client. There was no impediment to do it the way the legislature laid out. Why should we sit here saying, well, we think that's one way, but we're going to conjure up some other ways that we think are just as good, that are going to bypass some of those requirements and substitute other ones?
Well, what E&O has said and what the Commonwealth has repeated, this Court has repeated continuously, is that the children of non-traditional families should be treated the same way as the children of traditional families. And so when we're
E&O was about visitation. It was not about someone taking on a full panoply of parental rights.
It was at a temporary order stage. It was at a temporary order stage. And so what we're really talking about is what are the child's rights in this? When a child has been brought into the world in a legal manner, when the Commonwealth has not instituted any additional regulations so that single people are allowed to go to Boston IVF, label themselves as parent 1, parent 2, have a child. And, I mean, in this case, MP withdrew her consent at 18 months. At the time that there had been a parental relationship, if there were no parental relationship at the point that she withdrew her consent, I would suggest that I wouldn't be here. But this is what we're trying to protect at this point, is what happens when there is a parent-child relationship, when it's been consented to over a long period of time, so that the constitutional rights I believe you're referring to are, at this point, less strong because, in the cases suggest that she's waived them. What protection do you give children in this position?
Well, one thing you can do is give children visitation rights, for example. In other words, you started off your argument by saying what she's seeking here, and I thought it was a very clear statement, was to adjudicate her as a full parent. There are lots of people who are not full parents, and to answer Justice Cowan's question, there might well be a series of people that for very good reasons, they could be a grandparent, they could be, as in the case of, the first case where the child had been living with the aunt.
Humans v. Ramos.
Humans. There was a determination by the trial judge that this child, the best interest of this child for some period of time was to continue visitation. That's a classic best interest. When you get to adjudication of full parental rights, then we're into a somewhat different area.
I think I agree. And again, I would only suggest where there is explicit consent over a long enough period of time that there has been attachment, bonding, and there will be long-term harm to the child.
Put it this way, would I be correct in understanding, given the posture that was finally presented to the probate and family court judge, that the only issue for consideration was determination of adjudication as a full parent? Or could the probate and family court judge have determined that for a variety of reasons, which she laid out, your client was not going to be adjudicated a full parent, but that the continuation of visitation rights made sense?
I don't think that there's currently any room in the law for that. I think that's a...
Why not? Isn't that what Humans sets up?
that what E&O is?
E&O is a visitation case. E&O was just at the temporary order stage, but an E&O would say, and I think E&O's facts don't necessarily support E&O's holding, but what E&O would say is that you only have visitation rights if you have perform a share of the caretaking functions greater than that of the legal parents. So if one doesn't meet that threshold, one is not even allowed to visit.
But am I wrong, but does the ALI standard, not for estoppel by parent, which focuses upon the parenting function, participation in those significant life decisions, but the other category of de facto parent doesn't focus on parenting, but focuses on a lesser degree of involvement, on caretaking. Doesn't the de facto parent sort of invite visitation without custody?
No, Your Honor. Caretaking, and E&O did not define caretaking versus parenting.
But the ALI does.
Right, but if one looks at E&O, they elevated E&O to grant visitation rights because she had financially supported the child. If my client had supported the child, my client did financially support the child, and that wasn't even counted towards caretaking. But aside from that,
Let me ask you a different-
caretaking, at least not under the ALI. That's not caretaking. That's not the kind of bonding that we're talking about, which would overcome the legal impediments.
and that's why I'm suggesting, and I think the amicus brief you received yesterday, the Fathers and Families brief, which discusses the problems with
Well,
not
that's a
having
different issue,
breadwinning.
which is how we look at who contributes what to caregiving. In other words,
But this is all about the bonding. I mean, to get
and-
where you want, it's all about the bonding between the parents and the child.
That's correct, and there was the guardians ad litem in this case, which were the only professionals who saw the child.
But
The
doesn't
judge's findings, I mean, I read your brief about this argument. The judge's findings, it seemed to me, indicate that MP was predominant, found that this child could remain solely with MP without causing the child harm. And that seems to me harm to the child is what this is supposed to be all about. It's not the rights of the adults. It's the well-being of the child. And the factual finding that this child will not be harmed because the bond with MP is strong enough, solid enough. The bond with the AH, whatever it was shorter in duration, of a different nature. The finding that it's not going to harm the child seems to be
Well, I've argued that that's against the weight of the evidence and clearly erroneous, and that essentially what I think in any heterosexual or married couple, if they were dealing with the issue of compartmentalization, would refer the child to therapy or the parents to therapy. In this case, the suggestion was terminate contact with the other party, with the other person who was referred to as a parent.
Well, she didn't say terminate contact. Essentially, the decision for visitation would be up to MP.
And MP testified she was going to terminate contact.
and certainly at this juncture, for now. Who knows what will happen in the future?
Well,
But it does seem to me that de facto parenthood has to focus on whether the child is going to be harmed or not.
I agree.
And there was disputed expert testimony given on that subject. And, we may read the cold transcript and find your sort of closing argument a very persuasive one, but the judge who saw these witnesses credited MP's expert.
MP's expert had not seen the child, was not testifying about specific facts concerning the child, and MP testified that in response to cross-examination that you could develop a therapy plan to address compartmentalization, which, by the way, was something that was covered a paragraph and a half of a 70-page guardian ad litem's report.
thank you, Ms. Selden.
Thank you, Your Honor.
Mr. Foskett?
Isn't that the bottom line? If the judge's findings are supported by the evidence, then the judge followed the best interests of the child test, and that's really what's at stake here.
ultimately, that certainly is at least one of the primary issues, Justice Graney, and I think it goes just
Because de facto parenting, or parenting by estoppel, if we award that status to AH, involves a whole bunch of things, like how the religion the child's going to follow, the schools they're going to go to, the sports they're going to participate in, medical decisions that have to be made, et cetera, right?
That's exactly correct. I would go beyond that, however, and say that when you get to the issue in this court of reviewing the probate judge's findings on best interests, this court in the Yeomans case in 1999 made it crystalline that when it comes to issues of the child's best interests, and particularly focusing on contact with a parent, that is something that is best left to the probate judge. That's what the...
Mr. Foskett, let me ask you this question. And I understand your position is that her findings, which are lengthy and thoughtful and, are supported by the evidence. So let's assume that's the case. Let's go to a different case, though. There may be circumstances where you have a married couple where the father is unable to produce a child biologically and the wife is artificially inseminated by a known donor. And the couple live together as husband and wife, but he's not the biological father. And then there's and perhaps for, I forget the period of time, let's assume that, from the beginning of the relationship of living together here, 18 months, 2 years, I don't know for how long, what was the period of time or the length of this marriage, of this relationship, from the time they lived together?
In this case?
Yeah.
18 months. Oh, it was longer than that. It was 18 months from the birth.
No, I'm talking about the whole length of the...
I believe it was 2 or 3 years before that.
Sure. And, and they have this child, and the father, it is determined as between the two of them that it is necessary that one person's career progress, because it's more likely that a single person working full-time, I hate to say it in this day and age, will earn more than 2 people working part-time. And so he goes off and works. And then there's a very nasty divorce. Very nasty. First they're not arguing about anything, and then they're arguing about money, and then they're arguing about the child, and then they're arguing about religion and everything else.
I hate to interrupt, but isn't a married man presumed to be the father of his wife's child if he's consented to the artificial insemination?
I believe, actually, Your Honor, there's a statute in
Yeah.
Massachusetts
Makes him the father.
which says that he is the father.
Right.
Yeah.
How
Where
many,
it's-
how
where
many
it's done
legal
with consent.
parents how many legal parents can a child have?
I'm going beyond this.
When you say legal parents, I
Yes.
assume we're using that term as the ALI principles do.
The plaintiff in this case seeks to be the legal parent of the child. In this case, how many legal parents can the child have?
And the reason I ask
Okay.
for a definition of that term,
Okay.
Justice Cowan, is because the term legal parent is used in the ALI in a different, with a different meaning than parent by estoppel.
Okay, but how
or
many
de facto
legal
parent.
parents can the child
If-
have in Massachusetts in a situation such as we have
If we're
here?
broadening the concept to include these various alternates under the ALI, there's no specified limit in the ALI. I think that's one of the reasons, for
So
example.
then we could have an endless number, I mean, not an endless, but
it
a
doesn't
number
li-
of parents before. Okay, but if there can only be one, is there a situation in which there can only be one?
And that gets back to the way the ALI talks about this. The ALI looks at this principally, these two concepts of de facto parent and parent by estoppel, in terms of a legal parent having a relationship with another adult. And they envision that adult, if they comply with the requirements set forth in the ALI, becoming a parent. They don't use the term legal parent, but they use the terms de facto parent or parent by estoppel.
Well, if AH were to prevail and to be determined to be a legal parent, in this case, would there then be 2 legal parents of the child?
Well, yeah.
Well, there would be
It's like a
Yes.
husband and a
Right,
wife.
right.
there would be a determination
All right, then,
that they have full.
If we were to rule in favor of AH, aren't we inviting endless problems for this child, because these 2 people don't get along and they're not going to agree on whether the child should go to Sunday school or religious school, or what medication the child should take, or whether the child should sleep with an adult or not. How does it play out if we determine that there are two legal parents in this situation?
Well, and that
Well,
gets...
that goes to my question. I wasn't going to whether or not the father would have some light, but as I look at her findings, and you may, I mean, it may be that our law is that if you are the legal parent, you have to have some visitation, and she was making a determination here that it was in the child's best interest to have no visitation, correct?
Chief Justice, there actually is a Maryland case we've cited in our brief where, under the Maryland standard, which is slightly different than the ALI standard, the adult was determined to be a de facto parent, quote unquote, and in that case, the trial judge had been confronted with a similar situation to this one, which is that the disputes between the de facto parent and the biological parent had such an impact on the child that in that case, the trial judge denied visitation, and the Maryland Appellate Court sustained that decision.
That happens in traditional situations.
Well,
and that's why...
And what I'm looking to is if you look at the factors, and it may be here that you only get into the consideration when somebody is the legal... I'm trying to get through the levels. And that's why I asked Ms. Zeldin whether the only consideration the trial judge had was whether she somehow classify Ms. Zeldin's client as a parent first. It seems to me that there was a mixture here of what's in the best interests of this child with what the legal status is. And as I think Justice Sussman or Justice Spina, somebody at that end of the bench, was trying to sort out those two things.
And I think there had to be a mixture because, and this goes back to the adoption issue, if she had gone through with her pre-birth promise to adopt, and she was repeatedly asked to do that during the 18 months and refused.
Can I interrupt you? Just so that I want to make it clear that you understand what I'm focusing. I'm focusing on how we review what the best interests of a child are with regard to visitation. And I have to say, in part that's informed by the brief that was filed yesterday, where you have whatever the set of relationships is, legal or whether you call them de facto, but you essentially have somebody saying, because you were out working by agreement, because you couldn't spend as much time, because you couldn't, and so on and so forth, the bonding may not have been as great, but we conclude that there should be no visitation in light of the GALs saying some visitation.
I think there's a few points raised by that question. First of all, and I would hearken back to the recent Mason decision, the fact that the GALs make a recommendation is not binding on the trial judge. And in that case, having read the trial record in that case, there was actually no mention of a reason why the trial judge rejected the GAL's recommendation. Here, she goes into some detail, more than she had to, but she does. The other issue, I think the financial contribution issue doesn't have to do with the propriety of visitation. What it does have to do with is specifically the de facto parent test. Not parent by estoppel, but de facto parent. And that gets back to the colloquy that occurred when my opponent was arguing as to the definition of caretaking functions. What the ALI de facto parent test focuses on is whether or not there has been a two-way bond established between the adult and the child. And what they have done is say you focus on the caretaking during the period of residence. And then they define caretaking as these activities that involve direct interaction between the adult and the child or the direct arrangement of care for the child. Financial support and other things like that are classified and defined separately as parenting functions. And when this Court adopted the 1998 version, the definition in that version of the ALI principles, the same definition was in place. And so that doesn't go to the value of a working parent's financial contribution, nothing like that. It simply has to do with, if we're going to look at this de facto parent claim, we have to evaluate whether there was this parent-child bond, and so we look at caretaking, because that's how, certainly with a young child, that's how one establishes a parent-child bond.
Mr. Foskett, let me ask you this. when your client petitioned for child support and a visitation schedule, didn't that implicitly mean that she considered A.H. the de facto parent?
Your Honor, no. And in terms of whether or not there was legal status, let me explain that. There was visitation shortly after the separation and before the court ever got involved. And the reason there was because my client, acting appropriately as the child's mother and in the exercise of her constitutional right, determined that some continuing contact was in the child's best interest.
Yeah, but it goes
Because
beyond
they
that,
had a
though.
relationship.
Sure. But that doesn't mean that you're conceding that she's met the tests for de facto parenthood and the right to obtain visitation.
But a judge may have the authority, a judge does have the authority, to relieve somebody of the binding effect of judicial estoppel or of judicial admission. But here, the curious thing is, your client walked into court, you filed a petition, asked for child support, and asked for visitation, and made an admission that A.H. was a de facto parent.
Well, the case was commenced by the plaintiff. She
Okay.
brought
Yeah,
the case.
I take that back. But your client filed a motion for support in that case.
What was going on, Justice Spina, was that, as I said, the starting point is, as the mother, she agreed. This person had some relationship with the child. It wasn't enough to rise to the legal status of de facto parent, but she's not.
But actually, let me just finish my question. Why wasn't it an abuse of discretion for the judge to relieve your client of the binding admission?
Well, first of all, Justice Spina, the doctrine of judicial estoppel in the Commonwealth, as it's set forth in the cases,
It's a judicial admission.
Well, it requires that the court rely on it. And the motion judge specifically did not rely on it.
But a judicial admission is an admission of this nature that a court can relieve the party of the binding effect of if it's made imprudently. But here she was represented by counsel. She filed a motion for child support, for visitation, and made a statement to the, although against counsel's wishes, made a statement that A.H. was a de facto parent.
He's using the term in the context of the attempting to resolve these temporary issues while the case was being litigated. And if I may, there was a concession made by the other side at that same hearing in which her counsel stood up and told the motion judge that she was not seeking significance of a parental role.
Could I ask you, were the arguments about waiver or anything akin to that raised at the time the trial itself was about to start?
In what sense, Justice Ossoff?
I mean, in the sense, if
Or concession.
If the plaintiff is saying MP has conceded that I'm at least a de facto parent, and if the defendant is saying AH has conceded that she's not seeking full parental rights, did either side tell the probate judge before she launched on this 11-day trial, Judge, there's nothing to try here because both sides have conceded things?
No, and let's go back to the motion hearing in August of 2003 in front of Judge McSweeney. He was asked to make a law of the case determination on this issue, and he refused. And what he said to the parties at that hearing was, you can file some sort of legal document resolving this issue.
A stipulation or something? Yeah.
Something like that. Okay. And nothing was ever filed.
Did the issue did anybody thereafter, either side thereafter, start saying the other side has waived this issue in the case or this portion of the claim?
That was raised repeatedly. And the Judge McSweeney, in fact, was asked to deal with that again. He didn't. Judge Dilday, who had plenary responsibility for the case and ultimately tried it, was asked to do it. She refused to do it. The case went forward. It was litigated for 3 years. It was tried for 11 days over these issues of whether or not she has de facto parent status or parent by estoppel.
Can I ask you a different question? Just, I know your time is running out. In terms of the adoption itself, when were the papers prepared, and how long did they remain unsigned by the plaintiff in this case?
The papers, and Justice Corder, you have to go back to before the birth. They met with an attorney. The attorney prepared the papers. The attorney, in fact, prepared, in addition, papers that would allow them to expedite the adoption. After the birth, shortly after the birth, the papers were provided by the attorney to my client. She went through them, reviewed them, prepared them. It took her 45 minutes. She then presented them to the plaintiff. She refused to even look at them. She was asked on multiple occasions by my client during the course of this relationship following the birth to enter into the adoption. There is record evidence, which the judge found, that the plaintiff told her to get off her back, likened it to being nagged about doing chores, and ultimately, as the trial judge found and is supported in the record, this led to the separation. The withdrawal of consent was after she had spent 18 months refusing to take the 45 minutes to sign these papers.
I take it the ALI allows a judge to attach particular significance to the failure to adopt.
And if I may answer that, Justice Spina, the ALI discusses where their adoption was available, but there was a failure to adopt. They don't address where there's a refusal to adopt, although parent by estoppel, as we know from the terms of the ALI, turns on a co-parenting agreement, and part and parcel of that agreement in this case was the promise to adopt. So where the relationship is consensual, and this is all about the consent of the legal parent, how on earth can you say that there was consent where that consent was induced by a promise to adopt, which is then repudiated without valid excuse?
How old is the child now?
The child will be 5, I believe, in October.
5. And except for a very brief period of time, she has had contact with AH throughout.
That's correct.
Thank you.
Thank you
Mr.
very much,
Foster.
Chief Justice.